Good morning and welcome, or welcome back as the case may be. Excuse me, as the case may be. I'm Dean Reuter, General Counsel, Vice President, and Director of Practice Groups at the Federalist Society. Welcome to the third and best day of the National Lawyers Convention. Momentarily, we're going to begin our panel on originalism and unenumerated rights. Later today, we'll have the Rosencrantz debate, several panel discussions, several book signings, and an event featuring Justice Gorsuch. I'm actually doing a book signing myself for my new nonfiction World War II book, not a law and policy book. And I'm listed in the brochure as the Honorable Dean Reuter, and several people seem intrigued by that. You weren't supposed to laugh at that, but. So I thought I'd give the backstory on that. During the Obama administration, I tried to be helpful to Mitch McConnell and his staff by identifying good conservatives to serve on presidentially appointed bipartisan boards and commissions. So think the FTC, the SEC, the ITC. The Republican members of those commissions, even in a Democratic administration, are selected by the Republican leader. So I tried to help in that process, and after a while, his team eventually said that I should serve on a board for a grant-making agency at which I had worked some years before in the IG's office. So I was nominated by President Obama, confirmed by the Senate, making me the Honorable Dean Reuter. To my wife's chagrin, but I've got to finish this story by adding, somewhat relatedly, that I live very far outside the city, west of the city. We have these carpool rules here in Washington, created by bureaucrats. So years ago, I bought a hybrid vehicle so I could get in the carpool lanes even when I'm driving solo. So the bottom line is I am a Prius-driving Obama appointee, and I work for a nonprofit organization. So. Those are my sterling conservative credentials. So now to our panel on unenumerated rights and the credentials of our moderator, the Honorable Kevin Newsom. He is a judge on the 11th Circuit Court of Appeals in Birmingham. He graduated summa cum laude from Stanford University and magna cum laude from Harvard Law School, where he was the editor of the Harvard Law Review. He clerked for Judge O'Scanlan, who's here, I know. There he is, Judge, welcome. And then for Justice Souter on the Supreme Court. He served as Alabama's second Solicitor General for then Attorney General Bill Pryor and later Troy King. Still later, he headed the appellate practice group at Bradley Arent, arguing cases in the Supreme Court and appellate courts everywhere. We're so pleased to have him with us today. With that, please welcome Judge Kevin Newsom.
Thank you so much, Dean. Thank you, everyone. If it's okay with you, we're going to sit. I guess if you have a preference to come to the podium, that's fine, but I think we'll sit and speak to you from where we are. So this morning, does originalism protect unenumerated rights? I think if this won't get your Saturday morning juices flowing, at least for people, the types of people who are in this room, nothing will. So I hope you're as excited about this as I am. As Dean said, this is the best day of the convention. This is the best topic of the convention, and I have the best panel at the convention. So today we're going to talk again about, does originalism protect unenumerated rights? That will require us to explore what exactly originalism is. We have a vague sense for what it is, but our panelists will help to unpack it for you. What exactly unenumerated rights are. We may think we know what those are, but I think there will be a range of opinion about precisely what it means for a right to be either enumerated or unenumerated in the text of the document. We will talk about, among other clauses, the necessary and proper clause, the due process clauses, the Ninth Amendment, my personal favorite, the Privileges or Immunities Clause of the 14th Amendment, not the Privileges and Immunities Clause, but the Privileges or Immunities Clause. We'll also talk, if I might tempt our panelists, one or two of them to talk about the Republican form of government clause. I typically feel quite understaffed, undereducated to moderate panels like this. This is the one that I think I might plausibly be capable of moderating. My one little virgin foray into law review article authorship was an article about the Privileges or Immunities Clause, and so I've kind of been down this road before, but I think I have a lot to learn from these guys. So without further ado, let me introduce to you our panelists in the order in which they will present. Once they have presented their opening remarks, we might have a little bit of rebuttal, and then what I hope will be a robust exchange among them, questions if necessary from me, between them to one another, and then ultimately from you. So first, to kick us off, Stephanie Barclay at my far right, your far left, who is a professor at BYU, constitutional law expert, and a future clerk to the Honorable Neil Gorsuch. After her, we'll hear from Randy Barnett, whom you know well. Randy is a professor at Georgetown and the director of the Georgetown Center for the Constitution. And as I said to Randy on our planning call, he knows this. Randy is in part one of the reasons that I went to law school. When I was an undergrad, I fell into the sort of geeky habit of hanging out in the law school library reading law review articles. And I read a lot of Akhil Amar, and then I fell into Randy's book, Rights Retained by the People, a 2-volume set, a compilation of essays about the Ninth Amendment, which I really sort of fell in love with, and it led me in part to law school, so I appreciate Randy for that. After Randy, we'll hear from Judge and Professor Michael McConnell, who is the director of the Constitutional Law Center at Stanford, former judge on the 10th Circuit. After Michael, we will hear from Jamal Greene at the podium at the table to your right, who's a professor and a con law expert at Columbia. And finally, to wrap us up, Gary Lawson at your far right, who's a professor at Boston University, and as I think you probably know, a founding member of this organization, the Federalist Society. So we all owe him a debt of gratitude for that. All right, so with that introduction, let me give the floor to Stephanie, who will begin our discussion. Thank you.
Well, thank you to the Federalist Society for hosting this discussion and for the opportunity to be here. I feel particularly honored to be here amongst such a distinguished panel and that I'll get to hear from and learn from their remarks. And I'm also very glad to go first so I won't have to be the follow-up act of any of these giants in their field. So the question of whether originalism protects unenumerated rights is a big, complicated question that I think means different things to different people. For my remarks today, I want to break this down into some subsidiary questions that at least help inform my thinking about this topic. And I'll warn you that I'm going to come at these issues and think about examples primarily through the lens of expressive and religious rights, like we find in the First Amendment, which is where I focus a lot of my scholarship. And while we're speaking of the First Amendment, I will just say that there are some rights that are enumerated in the First Amendment that we treat like are not, like the freedom of assembly. And I know that my colleagues at Beckett would love if we took that right more seriously and if we looked at that and paid attention to the fact that that's one that actually is enumerated in the Constitution and gets very little attention. So as far as my 3 subsidiary questions, I want to think about what is the remedy in some of these contexts? Number 1. Number 2, which sovereign powers are reserved to the people in a system of popular sovereignty? And number 3, what is the standard of care the government is inherently expected to follow as a result of its fiduciary relationship as an agent acting on behalf of the people? This question, I think, is important to ask, not just with respect to the federal government as an agent of the people, but also with respect to state governments, which entails potential limits on their state police powers. And you'll have to forgive me, but I just can't resist speaking about police power without telling you very briefly about my recent run-in with police power. When I got pulled over on my way to drop my 8-year-old daughter, Siri, off at school. And when the policeman came up to the window and had made very clear that I had been speeding, my 8-year-old said from the back seat, "Mom, why were you speeding again?" I said, "Siri, please just let the nice officer and I have a conversation. Please be quiet. So he went to check on my license and registration, and when he came back, my daughter, I heard her pipe up again and thought, oh no. And she said, you know, officer, when you turned on your lights to pull us over, I wasn't actually buckled up. I just hurried and buckled so that you wouldn't see. And a little flabbergasted at this point, he said, why weren't you buckled up? Don't you know that that's not safe to drive around unbuckled? And she said, I know, my mom tells me that. But I was thinking that if our car drove into the ocean and we were sinking, it would be easier to swim away if I was unbuckled. So that's actually safer. To which this wise officer responded, well, there are no oceans in Utah. So I highly recommend that you stay buckled driving around from now on. And this kind officer ultimately did not give me a ticket. I hope Randy and I can agree this was not an arbitrary use of police power in this instance. So to my first question about thinking about remedies in the context of these rights, it's not enough to ask what a right is as a general concept, though we often focus on that. I think we also have to ask, how is that concept mechanized or applied in the real world? In other words, what is the constitutional remedy? And I think the constitutional remedies are often left unenumerated in the Constitution. They're not explicitly spelled out. Professor Jed Campbell has written about how in some contexts, like the First Amendment, there may have been broad consensus about some of these concepts regarding rights, but a lot less consensus about how to give meaning to those concepts in the real world. Further, even where there's an express constitutional requirement or prohibition, it doesn't necessarily follow that there's a federal judicial remedy that would enforce that right. We know this to be true for things that are not justiciable or political questions, and so I think it's just valuable as we're having some of these discussions to keep those concepts of constitutional protections and remedies in the real world separate. Where the Constitution doesn't enumerate the remedy for those rights, this can leave a fair amount of indeterminacy, and this is true whether we're talking about a traditional right that is a privilege or an immunity, or whether we're talking about a specifically unenumerated right. This is an area that some originalists describe as the construction zone, where an originalist understanding may permit a range of plausible options that are an acceptable remedy without necessarily requiring one. So in sum, I think it's important to treat this area of indeterminacy with respect to rights as a baseline, often applicable to any sort of right, and not something unique to unenumerated rights. So for the second question, with the people as sovereigns in a system of government, I think it's important to think about, and particularly when we're thinking about rights, where ultimate power resides. In British legal thought, the answer to this question, as many of you know, was Parliament. James Wilson stated that in England, the British Constitution is just what Parliament pleases. Blackstone famously described sovereignty as, quote, that absolute despotic power in which all governments must reside somewhere, end quote. In preparing this talk, my husband and I were chatting about this principle of sovereignty, and that somehow led to a friendly discussion about who the ultimate sovereign is in our family. And I think you'll all agree with me that the answer—
Sounds like Siri to me.
Yeah, the answer is pretty simple. Our daughter. That's what we decided. So after the revolution in America, the founders asserted that the people had claimed ultimate sovereignty, meaning that they were the seat of this authority in our country. The question of popular sovereignty and the understanding of this, I think, is important to understanding unenumerated rights because, as our Ninth Amendment suggests, the people as sovereigns were reserving certain powers to themselves and did not delegate those powers to government to exercise. James Wilson described the Bill of Rights as, quote, an enumeration of the powers reserved, end quote. One of those powers before the Bill of Rights that was reserved to the people as sovereigns was unrestrained censorial power. And notably, we see this exercised by the people, and they recognize that they're exercising it years before we had the First Amendment, and it was enumerated in the Bill of Rights. So it's an early example of a recognition of an unwritten right that is inherent in the Constitution and in the principle of popular sovereignty. Akhil Amar has written about how our Constitution came into being on a continent awash with speech and through a process teeming with expression. This was a sharp break from English longstanding law where the people did not enjoy the broad ability to criticize the government or government policies, and indeed Parliament as sovereign could hold critics in contempt. Madison contrasted that English approach with the American Republican approach and said, quote, "If we advert to the nature of Republican government, we shall find that the censorial power is in the people over the government and not in the government over the people," end quote. And while there was a lot of sharp-elbowed political maneuvering and disagreement, there was not widespread punishment for that expression. Speech took place, of course, in communities, churches, town squares, taverns, et cetera. But the constitutional ratifying conventions were possibly the location where this right being exercised was on its most full display. Even in conventions where one side had a decisive majority, whether Federalist or anti-Federalist, dissenters were still able to peacefully voice their opposition, and yet they went on, many of them, to still lead successful political careers. This is different even than what was going on leading up to the American Revolution, where those colonists who remained loyal to the crown were punished and treated as traitors. James Wilson, who was one of the great defenders of popular sovereignty, said of the Pennsylvania ratifying convention before any state had agreed to the Philadelphia Plan that, quote, "We at this moment speak and deliberate under this immediate and benign influence," talking about of popular sovereignty. And he also said, "In America, sovereignty continues, resides, and remains in the body of the people. Under the practical influence of this great truth, we are now sitting and deliberating," end quote. So in short, I think this expressive freedom is an example of something that was intrinsic and indispensable, an aspect of our Constitution, and a core component of our government, even before the adoption of the Bill of Rights had occurred. The third question to think about is what the government's obligation are to the people as agents of the people. Gary Lawson has written before, quote, "All federal actors under the Constitution exercise delegated authority from we the people as agents, and thus all federal actors under the Constitution are bound by a duty of care," end quote. So I agree with that. I think he's done a lot of important scholarship in this area. And this fiduciary relationship means that when government is acting as an agent of the people, that fiduciary standard of care implies that some government action is off the table in terms of legitimacy. As Justice Samuel Chase said, quote, "Government was a trustee of the people, accountable to them, subject to the will of the people," end quote. And Justice Story also wrote about this fiduciary relationship and how it created unwritten restraints on government as the principle to act, or excuse me, on government to act in a moral and beneficial way as an agent for the principle. Where there might be a little bit of daylight between my position and Gary's, although I'll let Gary speak to this, is that I think that this is also true of state governments and not just federal governments. As expressed by Madison, quote, "There are powers exercised by most other governments which in the United States are withheld by the people both from the general government and from the state governments." And he talked about how he continued to say, "Of this sort are many of the powers prohibited by the Declaration of Rights prefixed to the Constitutions or by the clauses in the Constitutions and the nature of such declarations," end quote. Early constitutional provisions written after the Revolution, I think, illustrate this new agency relationship between the people and state governments. Virginia's Constitution stated, quote, "All power is vested in and consequently derived from the people, that magistrates are their trustees and servants and at all times amenable to them," end quote. North Carolina, Maryland, Massachusetts, New Jersey had somewhat similar provisions. Some have also argued that the Ninth Amendment is merely a means of preventing state or local rights from being supplanted, meaning that power not delegated to the federal government was reserved for the state police powers. But one evidence I think that is suggests that it's not true, that the Ninth Amendment was just about state rights, is that in the antebellum era, there were 12 states who adopted provisions similar to the Ninth Amendment, and 2 states who adopted this same principle judicially. Southern states were engaging in egregious free speech suppression in order to prop up the institution of slavery and silence dissenters. This was an illegitimate act of government in a nation where the people were sovereign. That's a separate question from whether there was a federal remedy to rectify this injustice prior to the 14th Amendment. And that's indeed, I think, a large reason why we ultimately created the 14th Amendment, because there wasn't a remedy for these violations federally. But the Privileges or Immunities Clause, I think, correctly interpreted, is not meant to create a new right. That power already existed and really belonged to the people as ultimate sovereigns. But this new federal remedy was giving the people another option to enforce that right and that retained power that they had against the states. One concluding thought I'll make about this third question is the fact that I think government operates as an agent for the people doesn't necessarily, I think, equate to the judiciary being able to review everything that the government does. And I have some concerns about a Lochner-style approach. I think unrestrained judicial power raises concerns about not being democratic. And it's also an endeavor I worry offers little constraint, or that sometimes judges don't have the capacity to do well. So while it may be appealing to have the judiciary be a roving commission to ensure that the democratic branches of government are operating with the appropriate standard of care for agents of the people, such a system, I think, would raise questions about who will ensure that the judiciary is also operating in a way that is faithful to the limited powers the judiciary has been delegated by the people. And there's this countervailing concern that should inform our thinking here, and also, I think, gives reasons to have safeguards, ensuring that the judiciary is not frustrating the legitimate exercise of power that the people have delegated to the democratic branches of government. Thank you.
Wonderful, Stephanie. Thank you so much. Great way to kick it off. Randy, if you'll continue our conversation.
I'm going to stand up here because I can't see half the room from this place I'm sitting here, so hopefully this is better. Let me begin by offering a hypothetical. Suppose a state statute mandated that all children be taken immediately after their birth to be raised by state-controlled nurseries, as Plato recommended in the Republic. And that statute is enacted by the requisite majority of each chamber in a state legislature and signed into law by that state's governor. Would a federal or state judge have the power to declare that such a statute is unconstitutional? Or let me pose the question this way. Do you have a constitutional right to raise your own children when the Constitution says nothing about such a right? In my book, Restoring the Lost Constitution, I offer the following answer to this question, and I quote, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." Oh, wait, that's not me who said this. This is actually an entire amendment of the U.S. Constitution, duly enacted and ratified by the states. In my 8 minutes, I merely have time to identify 5 provisions of the Constitution, and the original meaning of which protects the unenumerated rights retained by the people. I will then explain how these rights can and should be protected by the judiciary. The Necessary and Proper Clause, the 9th Amendment, and the Due Process Clause of the 5th Amendment protects against federal infringement on unenumerated rights. And unenumerated rights are protected from state abridgment by the 14th Amendment's Privileges or Immunities and Due Process of Law clauses. The Necessary and Proper Clause requires that laws passed by Congress to execute its enumerated powers not only be necessary, but also proper. Gary Lawson has argued that for the 2 years we had a Constitution, but no First Amendment, a federal law abridging the freedom of speech, which would have been an unenumerated right at that point, would have been improper. But in the interest of time, I'm going to pass over this clause and leave to Gary whatever he might want to say about it, and now move on to the 9th Amendment, which I've already quoted. The rights retained by the people in the 9th Amendment refer to those individual rights that persons have in a state of nature before government is instituted among them, and which they retain after a government is instituted among them. The rights one has in a state of nature can be called liberty rights. These are the Lockean rights a person has to do what he or she wills or desires with what properly belongs to that person. They do not include positive rights or governmental benefits because there are no governmental benefits or government in the state of nature. Like the rest of what we now call the Bill of Rights, the Ninth Amendment originally applied to the federal government. But its rule of construction against privileging enumerated rights over unenumerated rights applies to the entire Constitution, including later amendments. Such later amendments include the Privileges or Immunities Clause of the 14th Amendment, which states that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. This is an expressed textual limitation on the legislative powers of states, which bars the abridgment of fundamental rights, which are not enumerated in that clause, belonging to all citizens. As explained by Justice Bushrod Washington in Corfield versus Coriell, these rights include, quote, protection by the government, the enjoyment of life and liberty, with the right to acquire, possess property of every kind, and to pursue and obtaining happiness and safety, subject nevertheless to such restraints as the government must justly prescribe for the general good of the whole, and also to take, hold, and dispose of property either real or personal. This formulation was a direct copy of the Statement of Natural Rights authored by George Mason for the Virginia Declaration of Rights and reproduced in the constitutions of 4 other states. Now, after quoting from the language from Corfield, Michigan Senator Jacob Howard, the sponsor of the 14th Amendment in the Senate, continued, quote, to these privileges and immunities, whatever they may be, for they are not and cannot be fully defined in their entire extent and precise nature, to these should be added the personal rights guaranteed and secured by the first 8 amendments of the Constitution. Now, having identified 2 provisions of the Constitution that expressly recognize unenumerated rights, I wish to stress that identifying such rights is not the same as explaining how they are to be protected by a judiciary. For this, we need to look to the 2 due process of law clauses located in the 5th and 14th Amendments. These 2 clauses require a judicial process. That's what they're all about. They're all about the judiciary. Before a person may be deprived of his life, liberty, or property for violating a federal or state statute. Now, what is the scope of this judicial process? Before any person may be deprived of their life, liberty, or property, there must be a judicial finding that they are A, actually guilty of violating B, a lawful command. They are actually guilty of violating a lawful command. This requires a realistic assessment of 2 questions. First, were they guilty of violating a properly enacted statute? Second, was the statute being applied to them within the proper or just powers of the legislature to enact? The due process of law, and we must always remember the of law part is in there, requires that no one be deprived of life, liberty, or property except for violating a valid law. As Justice Samuel Chase affirmed in Calder versus Bull, a statute that exceeds the proper power of the legislature is a mere legislative act and not a law. This distinction between a law and a mere legislative act can be found not only in Calder, but all over the founding era judicial decisions, including several by Marshall, including McCulloch versus Maryland, where he says, should Congress, under the pretext of exercising one of its powers, actually exercise a power that it was not granted, it would become the painful duty of this tribunal to say that such an act was not the law of the land. There's the distinction between act and law. For a federal statute, this requires a judicial assessment that a statute is within the enumerated powers of Congress to enact. So a Commerce Clause challenge is also a Fifth Amendment due process of law challenge, because its issue is whether the law is valid. The 14th Amendment's due process of law clause requires a similar assessment of state laws. But because state legislatures have general powers, this requires an assessment of whether a statute depriving someone of life, liberty, or property is within the police power of a state. It is therefore no coincidence that a theory of the police power was developed in earnest by Thomas Cooley and others starting the very year that the 14th Amendment was ratified, and raised the need for such a theory. In my book, Our Republican Constitution, I offer this summary of the police power of states, quote, that all men are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, unquote. Oh, wait. That's not me who said this. It is the Declaration of Independence, which is the officially adopted political philosophy of the United States. In short, the just police powers of government are those powers which are necessary to secure the natural and inalienable rights retained by the people. What then may legislatures do to secure these rights? There's a widespread consensus that the police power includes the protection of the health, safety, and public morals of the people. And by that I mean the moral behavior in the public sphere that is controlled by government. There is then a debate over whether it also includes bare moral legislative disapproval of acts performed outside of public spaces that violate no one's rights. But very few laws are actually justified this last way. What is normally at issue with a law is whether it was really not pretextually enacted in pursuance of a just police power, which requires some realistic assessment of fit between means and ends. It's usually health and safety. Before closing, I need to distinguish this traditional approach to the due process of law from the modern doctrine of substantive due process. Post-New Deal substantive due process puts the onus on judges to identify substantive rights, that's why it's called substantive due process, which are then protected by super-duper scrutiny, or whatever. Super-duper is close enough, that legislation will rarely pass. In contrast, the traditional pre-New Deal review of statutes for arbitrariness puts the onus on judges to examine the substance of statutes. So there is a substantive dimension of due process as well, but not substantive rights, but the substance of statutes to ensure that they are within the proper scope or limit of legislative powers. Which returns me now to my hypothetical statute authorizing a state government to take away our children to be raised collectively. Without doubt, such a statute restricts the background natural rights retained by the people. There's just no doubt that we all have that right in the state of nature. So we must then ask whether such a restriction is within the proper or just police power of a state. Now, this is an easy case for a police power theory that is limited to protecting the rights of each citizen from infringements by others. The clear answer to this question is no. This hypothetical is more challenging for a theory that empowers the state to mandate the morality of its citizens, but I won't explore that any further. Now, as it happens in the 2000 case of Troxell versus Granville, the Supreme Court, by a vote of 6-3, found that there was a constitutional right to raise one's child as one sees fit. Justice Thomas sided with the majority and even concurred to contend that the court should protect that right with strict scrutiny. Justice Scalia dissented. In his dissent, he conceded that, quote, "In my view, the right of parents to direct the upbringing of their children is among the unalienable rights with which the Declaration of Independence proclaims all men are endowed by their Creator. And in my view, that right is also among the other rights retained by the people, which the Ninth Amendment says the Constitution's enumeration of rights shall not be construed to deny or disparage." So far, so good. But he then contended that, quote, "The Declaration of Independence, however, is not a legal prescription conferring powers upon the courts, and the Constitution's refusal to deny or disparage other rights is far removed from affirming any one of them, and even farther removed from authorizing judges to identify what they may be and to enforce the judges' list against laws duly enacted by the people," and hence his dissent. Now, in my view, Justice Scalia was half right and he was half wrong, and at least on this day, Justice Thomas was the better originalist. Thanks.
Randy, thank you so much. And now to Professor McConnell.
Thank you. I'd like to begin by just pointing out what it is the topic. So Judge Newsom invited us to begin this way. So what are unenumerated rights? What are we talking about? All of this has to do with federal constitutional law. There are any number of rights that we have that have nothing to do with the Constitution. They may arise from common law, they may arise from federal or state statutes, they may arise from any other source. Just after the ratification of our Constitution, our founders wrote a Bill of Rights in which they decided on particular rights, all of them coming from the British constitutional tradition, although with some important expansions and changes. But they identified a set of rights reflected in the first 8 amendments of the Constitution. Those become what we call constitutional rights, and there are a few others located elsewhere in the Constitution as well. Those constitutional rights limit the power of the government, meaning Congress and the state legislatures, to pass laws that contradict those rights. And so just think about the language of the Bill of Rights. The First Amendment says Congress shall make no law abridging and then listing certain rights. So the idea of constitutional rights is that they are judicially enforceable limitations on the legislative power of the government. The mere fact, and everyone at the time of the founding understood that that list of rights in the first 8 amendments, and a few of them elsewhere in the Constitution, was not an exhaustive list of the rights that Americans would have. Common law, statute, all of those other sources of rights remain entirely in place. But those other rights are not federal constitutional rights. The federal constitutional rights are the ones that they set forth, and those are called, we call them enumerated rights. And those are the ones that the federal judiciary has authority by virtue of the Constitution to enforce, even in the teeth of contrary legislation that would otherwise be within the authority of the government to enact. Now, there are the modern practice, though, and really from it's been going on for the last 135 years. Dred Scott, I think, was the first example, but a modern substantive due process that Randy talks about as its current most important incarnation. Federal judges, sometimes state judges, but especially federal judges, reason as follows. Here is a right that we think the people ought to have. We think it's really fundamental. We think it's really important to dignity or to some other, or to democratic participation, or any number of possible moral arguments. This is something we really think ought to be a constitutional right, and therefore we are going to interpret it and enforce it, even in the teeth of the fact that the American people, through their representatives, have taken a different view. And in many of these cases, these conclusions about rights are expressly understood by the judges themselves as being matters on which reasonable minds may differ. Right? So we're not talking about, and think about examples like, well, shall I say, abortion is the most important of these in our modern jurisprudence. But the rights of parents to control the upbringing of their children, self-defense, assisted suicide. There are any number of claims of rights which are not among the enumerated rights in the Constitution. And the real question that I think is before the panel is what, if any, is the authority of the courts to decide upon these rights, often contentious and maybe even in the teeth of the judgment of majorities of the American people. When can the judges do that? And I think one might look at this question from a kind of 30,000-foot level and argue from the premises of a democratic government and reach, I think somewhat different conclusions than I think Randy sometimes reaches. But I'm not going to do that, because we were asked the question, what does originalism have to say? And originalism is a doctrine about reading the text of the Constitution. So I propose that we look at the text of the Constitution and understand the text of the Constitution in the way it would have been understood by those who had the authority to enact it. And the principal provisions of the Constitution that have been invoked by the courts in order to engage in this practice of creating unenumerated rights in the teeth of legislative disapproval are the Due Process Clause, the Ninth Amendment, and the Privileges or Immunities Clause. We could talk about the Necessary and Proper Clause later if you wish, or even the Republican Form of Government Clause, or my favorite, which is the prohibition on titles of nobility. That's my least favorite. I'd kind of like to become, Lord McConnell of Palo Alto, but I guess that's not going to happen. So beginning with due process, which has been the Supreme Court's chosen vehicle for assertion of the right to countermand the decisions of the representatives of the people. I think I largely agree with what Randy was saying about substantive due process. Just look at the text. It says that no person shall be deprived of life, liberty, or property, but it doesn't stop there, without due process of law. Well, what is due process of law? I agree with Randy, the most important thing here is the of law. That is to say, duly enacted legislation within the enumerated powers of the government. Now, as to states, the federal Constitution does not decide what the enumerated powers of state legislatures are. It leaves that to the people of each state in their own constitutional processes. And in fact, the 10th Amendment is explicit that unless there's something in the U.S. Constitution to the contrary, that the powers not delegated to the United States by the Constitution nor prohibited by it to the states are left to the states. So I respectfully disagree with Randy and with Thomas Cooley in their attempt to create a limited list of police powers to which the states are confined. That's just plainly contrary to the 10th Amendment and I think to the original understanding of the Constitution. The states get to do what they want unless there is something in the United States Constitution to the contrary. Now, actually, there may be state constitutional problems. There may be all kinds of other legal problems with the things that state legislatures might do, but it doesn't violate the U.S. Constitution unless it violates the U.S. Constitution. So of law, now at the federal level, I agree with Randy that it's very important to look to whether the power has been enumerated to the Congress. So there has to be a duly enacted law, and that law must be enforced through process, which is to say, through a neutral arbiter. Traditionally, this meant juries and courts. We can argue over whether other neutral arbiters like ALJs and so forth can provide due process. That would be an interesting debate. But the basic idea here is due process protects everyone's right to be able to exercise natural liberty, except when there has been a law duly passed and properly enforced. It does not give courts the right to say that there's some liberties that can't be infringed even with due process of law. It just doesn't say that, and no one ever thought that it did, that it meant that until quite late in 1870s, I think, at the earliest, unless we want to go back to Dred Scott, which is the first case that holds that. So due process, I think, is really a non-starter, even though that is the Supreme Court's chosen vehicle. Now, I think the Ninth Amendment and the Privileges or Immunities Clauses are much more promising sources for finding some authority in the federal courts to countermand legislatures. But I think that even giving them right now I'm going to give them a generous interpretation. Let me tell you, even my generous interpretation could be refuted. I don't think there's anybody on this panel who's going to defend the old, the sort of old Robert Bork style judicial restraint objection. So that doesn't mean there aren't arguments against this, but giving them a generous interpretation, this is what the Ninth Amendment and the 14th Amendment are quite different. Ninth Amendment is addressed to the federal government, and it comes out of a tradition of natural rights. The Privileges or Immunities Clause is directed at the state governments, and it does have a natural law backdrop, but its principally comes out of the nationalizing project of the Civil War, the conclusion that state governments, and I think now the southern states, that state governments were not a responsible protector of the rights of the citizens. So it is part of a project of making rights into a national matter rather than predominantly of a state matter. So the Ninth Amendment tells us that the enumeration in the Constitution of certain rights, think now they've just added the Bill of Rights. This is part of it. So the fact that we have enumerated all these rights in the first 8 amendments shall not be construed to deny or disparage others retained by the people. Now, first of all, what are these rights that are retained by the people? Any number of sources of rights. This is where I began. Could be statutes, could be common law. It could be natural law even. I believe it is, although there can be an argument about that. But the rights retained by the people are rights that they already have prior to the Constitution. These are not positive law rights created by the government. These are retained natural rights. I agree with Randy. He calls them liberty rights. Isaiah Berlin calls them negative rights. It is not possible to construe the Ninth Amendment to create such things as, say, welfare rights. Or, this is very controversial, but a right to marry is not a natural right. It is a positive right, and it cannot be addressed, logically is not addressed by the Ninth Amendment. So we're thinking of retained natural rights. Now, in the Lockean natural rights tradition, natural rights were not trumps. They are not the sort of thing that necessarily overwhelm a properly elected statute. You heard Randy reading you from Corfield versus Coriell, and I don't think he emphasized this language, but after listing what the natural rights are, it basically says, unless the legislatures have passed laws within their powers to restrain them. So the natural rights tradition it's kind of like common law in that these are rights we have that aren't written down, but the legislature, their background rights or default rights in the absence of legislative acts. And so what does the Ninth Amendment tell us that that the Bill of Rights doesn't do? It shall not deny or disparage these other rights that are retained by the people. Note that it does not say that they become federally enforceable constitutional rights. That isn't what they were the day before the Bill of Rights was enacted. And the Ninth Amendment tells us they have exactly the same status after the Bill of Rights that they had before. They're not going to be denied or disparaged. In other words, they're being held harmless. They're going to be the same. Now, how are these enforced? This is a very big topic on which I think Randy and I just don't actually disagree very, very much. But in the pre-constitutional tradition, when there were no enumerated constitutional rights, natural rights could be invoked in court, and courts paid attention to them, but through what we might call Blackstonian equitable interpretation. That is, Blackstone and some of the early American judges would say, here's a natural right. We are not going to assume that broad language in statutes not directed to that right are intended to abrogate a natural right. So it's basically something like a clear statement rule for the abrogation of natural rights. And on this side of of the Atlantic. A great example of this is the 1785 decision in Rutgers against Waddington, in which Alexander Hamilton was a lawyer for the plaintiff. And essentially what the judge there says is, when you have a natural right, that we are going to construe the state law narrowly in order not to overturn it. But if the state's legislature, the legislative authority, the representatives of the people, specifically and intentionally abrogate the right, well, in the end, natural rights don't survive that kind of an enactment. And in the end, there's legislative supremacy with respect to natural rights. Well, what about the Privileges or Immunities Clause? This state, says that no state shall make or enforce any law that abridges the privileges or immunities of citizens of the United States. I agree basically with Randy's construction of this. The authors of the 14th Amendment certainly referred back to Corfield versus Coryell and other small handful of antebellum cases. And so what were the privileges and immunities? And there was a list. It isn't a complete list. This is not exclusive, but it's also the rights that are listed in the Civil Rights Act of 1866. They are essentially the rights to, to have, own, use, sell property, so property rights, the right to enter into contracts, so property rights, contract rights, the right to the protection of the laws for the protection of persons, so basically tort law rights, the right to sue and be sued. So it's civil procedure. It's basically the first year law school curriculum. And the right to have the same criminal law applied to you as applied to any. Now, the Corfield versus Coryell was about discrimination against out-of-staters. It was about what rights a citizen of Massachusetts would have when in South Carolina. And a citizen of Massachusetts is not to be treated like an alien. When you're in South Carolina, you have the right to buy property. You can enter into contracts. You're subject to the same tort law. That's what the Privileges and Immunities Clause of Article 4 was all about. Now, what does it mean when in the 14th Amendment we now say that no state may abridge the privileges and immunities of citizens of the United States? All of those Corfield versus Coryell rights are actually common law rights that we understand as arising from state law. What does it mean to say that they become privileges and immunities of citizens of the United States? Legal historians differ about this. My personal view, though, is that the only way all of this really makes sense is to say that the framers of the 14th Amendment understood that certain of these rights are actually common among the country as a whole. So we have certain, there's certain things like the right to contract and property and so forth, and that they become a kind of common heritage of the country as a whole. And what the Privileges and Immunities Clause says is that states cannot discriminate among their citizens in withholding certain of those rights. So we're really thinking here of the freedmen and the aftermath of the 13th Amendment. The black codes of the South, which were the particular target of the 14th Amendment, essentially tried to come as close as possible to recreating the conditions of slavery by saying that persons of African descent may not own property, fully exercise contracts, they're subject to different criminal laws, et cetera, et cetera. The Privileges and Immunities Clause says no, as to these sets of common rights that are now commonly accepted across the country, the states can't single out some of their citizens and say that they can't have them. Now, what does this mean? For us today as a source of unenumerated rights for federal judges to overturn legislatures? I think it may give it gives some color to claims of deeply embedded widespread rights, so that a right which has been recognized for a considerable period of time, essentially on an almost national basis, becomes a nationally recognized right. Griswold versus Connecticut doesn't rely on the Privileges or Immunities Clause, but it should have. In that case, Connecticut was actually the only state in the Union that still forbade the use of contraceptives by married couples. And so if every state has now recognized this as a right, the reasoning in Justice Harlan's concurring opinion comes very close to saying, well, that's become a privilege or immunity of citizens. What it does not give the court the authority to do, in my opinion, is to create new rights in the face of consensus to the contrary. So look at, say, dare I talk about Roe versus Wade? I can no longer be impeached, so although my tenure might be at stake for saying something as radical as this, but at the time of Roe versus Wade, at least 45 and arguably 49 of the states rejected the idea of abortion on demand. So when the court recognized that unenumerated right, it was not enforcing a national longstanding consensus such as might be supported by the Privileges or Immunities Clause. Instead, the court was imposing its highly questionable will on a highly contentious moral issue about which we Americans disagree, and saying that representative government has to give way to our opinion. Why? Because our opinion is right. And that, I think, is not within the original meaning of the Privileges or Immunities Clause. Thank you.
All right, Michael, thank you very much. And next up, Jamal.
Thank you. Thank you for having me. It's always hard to follow Lord Michael of Palo Alto, but I will do my best. So to the degree the question we're being asked to think about here is whether the original meaning of the Constitution protects fundamental unenumerated rights, I think there's a fairly straightforward answer to that question. I agree with Randy and to some degree Michael as well, that the Privileges or Immunities Clause of the 14th Amendment protects the civil rights of citizens. That includes, as we've heard, the sort of common law rights, first-year curriculum rights, the right to sue and be sued, the right to appear as a witness in court, the right to own and convey property, the right to enter into and enforce contracts. I would include among those something that isn't a first-year curriculum right, which is Randy's right to direct the upbringing of one's child. I think that if South Carolina had denied that right only to citizens of Massachusetts prior to the 14th Amendment, that would be a violation of the Article 4 Privileges and Immunities Clause. I took Michael to disagree with that, so there's a little bit of disagreement. But I think there's a great deal of evidence that the framers and ratifiers of the 14th Amendment would have understood those rights, or it's a little bit hard to specify them, but some set of those rights as substantively protected against state infringement, at least without any good justification. They're enumerated in the sense that they are sourced in a constitutional text, but they're not specified. Now, of course, rights to contract are not the rights that the current Supreme Court treats as fundamental, and so the question for the panel might more interestingly be whether there's a right to abortion or birth control or marriage or sexual privacy or a right against forced sterilization, let's say, to be found within the Constitution's original meaning. I think the answer to that question might well be yes. I'm not going to dwell on it very much unless people want to, but I think the answer to that might well be yes. I think there's a decent argument that taken together, the Citizenship Clause, the Privileges or Immunities Clause, and the Equal Protection Clause give or protect equal access of citizens to certain important rights. That those rights were left unspecified precisely because to specify them was difficult, unknown, left for downstream adjudicators in their wisdom and judgment. I think that the right to equality and the right to liberty are not so easy to separate in a kind of hermetically sealed way as we sometimes believe. And so there's a lot of ways in which thinking about equality rights blends into thinking about liberty rights. I think that's probably the more sensible way to approach something like abortion rights. The other thing I'll say is that there are, I think, certain individual rights that can be implied from the constitutional structure. Again, I'm not going to dwell on that either, but the right to vote is not specifically enumerated, but I think is protected via the constitutional structure. What I want to spend the bulk of my time on, actually, is a somewhat less straightforward, I think less obvious proposition, namely that and I want to talk about the Ninth Amendment as Randy did and as Michael did, but I want to think about it as a repository for entirely unenumerated constitutional rights that are protected by state and local representative institutions, which is to say rights protected through law as opposed to rights that are fundamentally individual or natural rights. As Randy indicated, the Ninth Amendment, I think, is a fairly direct statement in the Constitution that it should not be read to protect only enumerated rights. What I want to emphasize, though, is that the rights retained by the people, as the Ninth Amendment specifies, are not just some kind of free-floating set of rights waiting to be discovered by federal judges, but neither are they just an inkblot, as Judge Bork said at his confirmation hearing. Rather, the way in which the people recognize and develop rights is through state and local representative institutions. Those are state and local legislatures. Those are juries, fundamentally. Those are the militia. Those are state and local churches, which would have been understood as places for public deliberation. I see the Ninth Amendment primarily, though not necessarily exclusively, as shielding the rights protected by and through these state and local institutions from undue federal interference, and that includes undue interference by federal judges. And the way I get there is by looking at the full context of the Bill of Rights. We often think of the Bill of Rights as embodying a commitment to individual liberty as against the federal government. On this view, the protected rights are individual entitlements to thwart the will of democratic majorities who would otherwise get their way. Judges are therefore needed on this view to defend rights because the judges are insulated from majoritarian politics. But that's a very modern view of how we think about rights. The Bill of Rights was not inspired by that vision and doesn't take that form. The Bill of Rights was placed in the Constitution not to protect individual rights as such, but to limit federal power. And limiting federal power meant the preservation of existing state and local representative institutions, which were modes of governance, legislatures and juries, again, primarily, but they were not inconsistent with that, the very institutions through which citizens protect their rights. So, for example, the First Amendment's speech provision originally protects against prior restraints, but not necessarily against subsequent liability for harmful speech. Why would you make that distinction? You would make that distinction because juries are a vital protection against liability for alleged harmful speech, but those can be evaded through a licensing scheme or a prior restraint. The Establishment Clause, right, protects against federal interference with established state churches at a time when, in much of the country, again, churches were important sites for public deliberation. The Second Amendment protects the militia, an important mode of local policing from federal regulation. The Third Amendment preserves the primacy of the militia by denying the quartering of federal troops. The militia, of course, didn't need to be quartered because it was local institution constituted by individuals, local individuals, and so that helps to guard against standing federal army. The Fourth Amendment protects against unlawful searches and seizures by placing a local governing institution, that is the jury, which can decide reasonableness, in between the feds and individuals. When a jury is not present, as in a situation in which federal officials are trying to obtain a warrant, the substantive standard is increased, not decreased, increased from reasonableness to probable cause. The Fifth Amendment, you see the pattern here, but the Fifth Amendment requires a grand jury in federal indictments, so that protects juries directly. It requires just compensation for a federal taking, which should ordinarily be a jury question, per the Seventh Amendment should be a jury question. It protects the jury's verdict through double jeopardy. The self-incrimination clause protects against prosecutors circumventing the jury's fact-finding role through coerced confessions. The Sixth and Seventh Amendments protect juries quite directly in criminal and civil cases, respectively. The Eighth Amendment ensures that the jury's sentence, the sentence is supported by the jury's verdict and not added to, in some sense, by federal judges. The Tenth Amendment directly protects the reserved powers of states. I go through this list to show just how pervasive the theme is, which is that the Bill of Rights protects rights indirectly by allowing them to reside within local legislative and adjudicative institutions. It's directed towards making sure that outsiders do not circumvent those local, inside institutional processes of rights elaboration. Those local institutional processes were the ones to which the founding generation entrusted rights. What this means is that one significant place to look in determining what specific rights the Ninth Amendment protects is those rights that are embedded within state and local institutions. It also means that in thinking about how far those rights go, it makes sense to take seriously what it means for rights to be recognized, developed, and elaborated through a political process rather than through a process of legal interpretation, which is to say that they're virtually never absolute, but are constantly subject to the police power of the community. That's the way in which local institutions typically protect rights. And so I'll just close with a very quick example of how one might operationalize the kind of institutional view of the Ninth Amendment that I'm suggesting, which is Lochner versus New York. On the institutional view, the one that I've just kind of tried to defend, Lochner's problem is not that the majority invented rights to contract. I think there's plenty of reason to think the Constitution does in fact protect rights to contract. Rather, the problem with the Lochner court was that it gave insufficient weight to the labor rights that were protected through state law. The Ninth Amendment gives some protection to those rights, not absolute protection, but some protection to those rights, even protection from federal judges who might wish to interfere with them by protecting rights to contract too robustly.
Thank you. All right, so we're going to wrap up the initial presentations with Gary Lawson, and just to forecast a bit, we're at 10:10. We've got to wrap up here at about 10:40. So when Gary's done, we might have a little bit of rebuttal up here, but I want you to be thinking about questions that you may have for these guys, most importantly. So Gary, finish us up.
All right, I'm going to come at this topic indirectly, or as you might say, come at it Yale. So I want to start with a much more basic question. Does the Constitution contain unenumerated anythings? And the answer is obviously yes. It contains lots of unenumerated things. Here are a few examples. There are interpretative principles that are unenumerated, but that are clearly part of the Constitution. There is no clause in the Constitution that says, read me in English. But of course, you should be reading the Constitution in English. And if there was a clause, you would have an infinite regress of clauses because you need to read that one. And it's actually even more specific than that. As John McGinnis and Mike Rappaport point out in a very important article just published last year, what the Constitution really says, unenumeratedly, is read me in a dialect of English that you might call legal English. Very, very important unenumerated idea. Here's another one. Read me seriously and not sarcastically. Congress shall make no law abridging. Yeah, like we really mean that. There's no anti-sarcasm clause in the Constitution. And again, there would be an infinite regress if there was. That's an unenumerated principle that's really quite important. If you don't have that notion that you're reading the Constitution seriously and not sarcastically, you're going to get very, very different results. And there are contexts in which you would read documents sarcastically. If the Constitution was a poem, by some beat hippie or something, you might well want to read it. It was written by Monty Python's Flying Circus. You might well want to read it sarcastically. So these sound trivial, but these are all unenumerated ideas that are essential to and part of the Constitution. Well, the Constitution isn't a poem, and it wasn't written by Monty Python. What is it? Well, it says it's this Constitution, but as Douglas Adams would say, yes, but what exactly is it? And Stephanie actually pointed out the answer. The Constitution is a kind of fiduciary or agency instrument. Is there a clause that says so? No. There were state constitutions of the time, by the way, that had clauses that said that that's what they were. The U.S. Constitution doesn't have an express clause that says it, but it's certainly implicit to the point where it's a fair judgment to say that's part of what the Constitution is. That's an unenumerated idea, but as I'll explain as I go, essential to answering the rest of the questions. Well, okay, you might say that's all cheating. We're not really talking about interpretative principles and reading the Constitution in English. What about the powers and rights, the stuff? Okay, well, let's start with unenumerated powers. Does the Constitution contain unenumerated powers? Well, actually, it kind of does. Once you've acknowledged, as I think one can acknowledge, that the Constitution is a kind of fiduciary or agency instrument, as Stephanie mentioned, well, standard 18th century agency law said when you grant agents powers, ordinarily, there are incidental powers that flow from the express grants. Now, that inference can be overcome by a specific clause in the instrument that says otherwise, as the Articles of Confederation did. The Articles of Confederation contained a clause that expressly excluded incidental powers. The U.S. Constitution doesn't. Well, it sort of, kind of does. Congress, as an institution, can't claim unenumerated incidental powers because there is a specific clause dealing with Congress's incidental powers. That's the necessary and proper clause. That's what that clause is. It's a codification and therefore a definition and cabining of Congress's incidental powers. So Congress's incidental powers are enumerated, not unenumerated. What about the president and the federal courts? They don't have necessary and proper clauses cabining and defining their incidental powers. Are there things that are incidental to and therefore exist even though unenumerated to the executive and judicial power? Again, I think the answer has to be yes. I don't know if Jim Fander and or Amy Coney Barrett are out there because there are lights glaring in my face and I can't see any of you. But if they are, they, along with others like Robert Pushaw, have written very important work talking about the incidental powers of federal courts, what things go along with the judicial power as a necessary incident. Yeah, absolutely, there can be unenumerated powers of federal institutions. Well, what about unenumerated powers of the United States as an entity? And here the starting point is that there are no enumerated powers of the United States as an entity. Every single grant of power in the United States Constitution is to some specific institution or actor. There is no clause in the Constitution, none, zero, zilch, that grants power to the national government or the federal government as an undifferentiated entity. So are there any unenumerated powers of the national government as an undifferentiated entity? Well, again, the answer, I think, is yes. Not the ones that the Supreme Court has made up over the last 150 years. There was a period of about half a century from roughly 1870 into the 1920s and 30s when the court got very fond of a kind of reasoning that went, all self-respecting governments can do X. The United States is a self-respecting government, therefore the United States can do X. That's a lousy kind of reasoning given the nature of the US Constitution, but that's the kind of reasoning that gave implied powers ranging from dubious to ludicrous of such things as federal power of eminent domain, not recognized till the mid-1870s, by the way, federal power over immigration. There is no enumerated federal power over immigration. Power over Indian affairs other than commerce with the Indian tribes, the military draft. This kind of reasoning infused cases from Missouri versus Holland to Curtis Wright. There's lots of stuff that case law from the last century and a half recognizes as unenumerated powers of the federal government. I think all that is nonsense, but there are some, not many, tiny, small, but some unenumerated powers of the federal government stemming from the federal government's character as a corporation. And by corporation, we mean an 18th century corporation, not a mid-19th century post-general incorporation statute corporation, because all government entities were corporations in the 18th century. And there are certain things that just go with corporate status, certain things you can do just by virtue of being a corporation, even if they aren't enumerated. The right to sue and be sued, right to have a seal. There's no clause in the Constitution that says the United States government can have a seal, but it can have a seal because it's a corporation. Power to hold property. The United States as an entity held property before there was a constitution. Who held the Northwest Territory before there was a constitution? It was the United States as an entity. So yeah, there are certain powers that are unenumerated that belong to the United States as an entity. Again, they're not a whole lot, not a big deal, but they're absolutely there. So conceptually, we're asking, well, are there also unenumerated rights? Well, that should not be an odd notion. Unenumerated principles of interpretation, unenumerated powers, unenumerated rights is not an odd notion. Okay, now we get to the main event. Are there unenumerated rights? And if so, what are they? Well, again, I think the answer is yes, but they're not necessarily what people think. And let's start with the observation, and this has come out. Jamal pointed it out. I think several other people did as well. The places that people normally look for unenumerated rights are not actually unenumerated. They're enumerated. The due process of law clauses, those are enumerations. The privileges or immunities clause, that's an enumeration. The Ninth Amendment, that's an enumeration. All the stuff Randy was reading, those are enumerations. Now, there are all sorts of nasty questions about what exactly they enumerate, but those are, I would submit, ordinary questions of interpretation. Those are the sorts of things that original interpretation is designed to do. What I want to focus on is whether there are unenumerated rights that don't depend on how the debates between Mike McConnell and Randy Barnett come out, that don't depend upon how you wind up interpreting the enumerated provisions, right, that don't necessarily spell out in crisp detail what the rights are. And I think there are some of those as well. Again, they're not enormous, but they're actually quite important. And as Stephanie hit on this one as well, once you recognize the Constitution as an agency or fiduciary instrument, there are certain duties, obligations of agents that were standard, part of the background in 18th century agency law as they are today. Again, those duties can always be canceled, modified, enhanced, whatever, by the instrument, but they're there as a background rule. The duty of personal exercise of discretionary authority. That is, by the way, where the constitutional principle against subdelegation really comes from. Duty of loyalty. Duty of care. What Stephanie talked about. Absolutely, there is a background rule of duty of care for any agent. Does that correspond to what we might call substantive due process? Well, it corresponds. It's analogous to it. It's different from substantive due process in three important respects. Number one, it doesn't come from a clause, so it's not an interpretation or misinterpretation of the due process of law clause. Doesn't apply just to Congress, it applies to all federal actors, including the president and the federal courts. And the standard baseline 18th century standard of care was a whole lot stricter than rational basis. It was looser than negligence. There's a classic 18th century English case that talks about supine negligence as the standard, and that's probably right. But what that means is that all the grants of power to federal agents as agents come with an implicit unenumerated coda. Oh, for heaven's sakes, be reasonable. And if you want to go around calling that substantive due process, it's not, because it's not due process of law. But that's basically right. So am I saying as an original matter something like substantive due process is correct? Yeah, I think it is. Sorry. There's another one that's just as important. What happens when an agent represents multiple principals? Also circumstances where that could happen. You could go off with a ship full of stuff from several different merchants, and there's a storm, and you got to toss a bunch of the cargo overboard. Whose cargo gets tossed? Or you're administering an estate, or you're exercising a power of appointment to dole out the estate to the kids or the grandkids. How do you do that? Well, again, the background norm in 18th century agency law was that when you're dealing with multiple principals, you have to treat the multiple principals fairly. Not necessarily equally, but fairly. Right? All of the federal agents represent multiple principals, like several hundred million of them. So does that mean that federal agents have what we might call analogously an obligation of federal equal protection? Well, again, I think the answer is yes. Not because there is an equal protection clause, there isn't. Not because the 14th Amendment equal protection clause is reverse incorporated, it isn't. But because independent of all of those clauses, the nature of the Constitution as an agency instrument carries with it, unless it's canceled by something else, the obligation of the agents acting to treat all of the multiple principles fairly. And if you look at the 18th century cases that are the closest to this, the powers of appointment and the administration of wills, equality serves as a starting point, as a baseline norm, but if you have good reasons for departing from that baseline norm of equality, that's okay, because the underlying norm is one of fairness, not of equality, which means a strict, unconditional rule of federal colorblindness probably is not defensible as a matter of original meaning. Now, the place, as Stephanie predicted, where I part company with her, is all of these unenumerated things that sound so awful and wild, and how can an originalist be saying all of this stuff? That only applies to the federal government. Not because state governments are not fiduciaries and agents. They are. But because their status as fiduciary agents does not come from and is not regulated by the federal Constitution as an agency instrument. There may very well be instruments, their own state constitutions, that govern what they can do and define their powers and obligations as fiduciaries. I just don't think the federal Constitution does that. It doesn't do that particular work. So with respect to what the states can do, nothing that I've just said has any bearing on any of that. So if you were hoping that I would end with something like a grand constitutional right against the states to kill babies or marry your cat, sorry, that's just not going to happen. But with respect to the federal government and the federal actors, and again, this is not just Congress, this is the president, this is the federal courts, this is citizens acting as grand jurors as a federal institution. All of them, I do think, have unenumerated obligations which correspond to unenumerated rights of the principals, the people against whom they are exercising power, that look suspiciously like fairly rigorous applications of what today we doctrinally call substantive due process and federal equal protection. And if that doesn't generate something, I don't know what will, so I'll stop there.
All right, so because by my watch we have about 12 minutes left, what I'd like to do is cue up the microphones. Unless there is rebuttal that's just burning a hole in the side of someone's mouth, I'd like to hear from you. So if you have questions, please queue up at the microphones. Let's start over here. And again, as Gary said, I can barely see you, but I know you're out there.
Okay, thank you, Judge Newsom. Michael, Roger Pilon here at the Cato Institute.
What would a FedSoc convention be without Roger asking me a question?
Well, thank you. I would like to go after your misreading of the Privileges or Immunities Clause, but rather than do that, I'm going to pose a question of a higher order. Namely, that in your wide-ranging discussion, you try to distance yourself from Robert Bork, as, for example, when you said that judges should, they may have to do some, the enforcement of some enumerated rights, like those that are deeply rooted in the nation's tradition, alluding, therefore, to Glucksberg. Well, the problem that I have with your argument is that at the end of the day, you're privileging majoritarian democracy over individual liberty. And that means that your view is essentially, like Bork's, no different from the post-New Deal majoritarian liberals. And so I wonder how you square that with a Constitution that was designed to skewer individual liberty rather than privilege majoritarian democracy.
So, individual liberty. If one person has a right, someone else is going to suffer as a result of that. If there's an abortion right, there's an unborn child who is going to suffer from that. If there is an absolute right of parents to control the upbringing of their children, there are going to be children who are going to suffer neglect and so forth. So the question is, how do we balance these various rights? And I do not see it as state versus individual rights. I see it as judges making their own moral judgments as opposed to the people of the United States making a collective moral judgment. And as to them, I mean, I hate to be disloyal to my former tribe, but I'll trust the American people any day. And I also think that that's what the Constitution does. So the Constitution gives the government certain powers, and then it limits their powers in particular ways, but those particular ways were put in there through a super democratic process. And I'm not willing to say that an unelected group of people who are not representative of the American people in any way get to have the final word on all these things.
Kevin. Yeah. Actually, I haven't been heard from for like over an hour. Let me just, I think that's a little too facile. I mean, as we heard last night from Attorney General Barr, we had a government that was set up because parliamentary supremacy was not accepted here. That founders did not equate the people of the United States with their legislatures and government. The legislatures, those are two different entities. And just to equate one with the other is the post-New Deal way of looking at things. It's also a pre-New Deal as well, that I think just goes too fast. You have to ask yourself, what were these delegated sub-assemblies? What are the checks and balances upon them? Last night we heard about the executive branch being a check. All of these agencies should be limited, including the judiciary, but it's just too quick to say, oh, well, we trust the people. Yeah, you may trust the people, but do you trust the legislatures who are not the same as the people? One more thing, I just want to stress the degree to which Mike and I actually agree about most of these things. There's been a sea change in the way conservative legal movement has considered the due process of law since I started with the Federalist Society years ago. It used to be that the due process of law was thought to be satisfied as long as a statute, the of law part of the due process of law was satisfied as long as the statute was a duly enacted law by a state legislature. You had to be passed by the requisite majority and signed by the governor. That's the due process of law. You might call it the due process of legislation. But there is an increasing consensus among constitutional scholars, including Mike and his co-author, Nathaniel Chapman, and myself, that of law does more work than that. They have a separation of powers theory of what work that of law part does, and I think that they're right in many cases that they talk about that. But there's more to it than that. Mike says that this idea that you would go beyond a separation of powers view to view what of law was before was something that was invented in the late 19th century. There are earlier cases which in their articles they dismiss as outliers. But I think, they were unusual, but not necessarily outliers. The final thing I will say, because I'm limited, I had a lot of stuff more to say. The final thing I'll say is that Mike started his talk. This is one of the areas where we do disagree, I think, but I don't think it makes that much difference, is that he distinguished between federal constitutional rights and natural rights or background rights. And he said that those are the ones that get put in the Constitution. Well, if that were the case, that would mean that for 2 years there was no constitutional right of freedom of speech in this country until the First Amendment was enacted. And if that were the case, you would think the enactment of the First Amendment was a really big deal, that everyone would say, oh, we need this amendment because we don't have such a constitutional right. And then after they got it, they'd celebrate, we've got this constitutional right we didn't have before. As far as I know, no one said anything like that. No one said anything like that. The only complaints about the First Amendment and the rest of the amendments by such legislatures as Virginia's, they didn't go far enough. They didn't protect the rights of states the way the Anti-Federalists had wanted. They merely protect individual rights, which are already protected. And so if there had been that big distinction between constitutional rights, which are enforceable, and mere natural rights, which are not, the enactment of the first 10 amendments would have been huge. It was not huge. I don't think that that's right. I do think at the end of the day, when my co-author Evan Bernick and I do cash out how you discover the privileges or immunities of citizens of the United States, you're going to find we do something very similar to what Mike recommends at the end of his talk, where he talks about certain rights that are common in the country as a whole, and the only difference would be he would limit the protection of those common to the whole rights to discrimination, and we think those rights historically were protected absolutely as well as from against discrimination.
Yeah, one quick thought. If I hadn't given the talk that I did, the talk that I gave would have been a thought experiment, which says, imagine which laws on December 14th, 1791 would have been constitutional that would have become unconstitutional the next day when the Bill of Rights was ratified. And it turns out it's a fairly thin list.
All right, let's see if we can get at least one more over here.
As was alluded to early in the talk, there are a number of states that have versions of the Ninth Amendment in their own state constitutions, and these are 33 if you add them all up. They were enacted all the way from 1819 to 1970 is the most latest one. There's also these things that Professor Calabresi calls Lockean natural rights guarantees that take language straight out of George Mason's draft of the Virginia Constitution, and they've been enacted at various times. If you put these two together, there's over 40 state constitutions that have pretty explicit protection of unenumerated rights. So not that this changes our understanding of the U.S. Constitution, its text, but does this show that across the ages, Americans have been quite comfortable with unenumerated rights? They put them on their own state constitutions when they have conventions. And does that show that interpreting the Ninth Amendment, the Due Process Clause, the Privileges and Immunities Clause to protect unenumerated rights isn't an off-the-wall idea? It's actually something that Americans are quite comfortable with.
Stephanie, I was wondering if you might start with that, since you and Gary have this disagreement about the fiduciary nature of the federal constitution vis-a-vis the states.
Sure. So thanks for that helpful information. I think that the state constitutional things that look like Ninth Amendment or those sort of Lockean promises you're talking about do suggest that states took serious, or the people took seriously, the idea that there were limitations on government power. They go to this fiduciary nature that Gary is talking about. And I think that Gary's right that the federal constitution creates some of that fiduciary relationship, but I also think some of that is inherent in the fact that the people inherited sovereignty in the United States. And so that creates limits with their relationship with government at both the state and federal level. And I think that you're right that the fact that some of these guarantees are in the state constitution suggests that there was more widespread understanding about that. How you mechanize that, what the actual remedies are about that, I think that's a separate question, but I'd love to hear Gary's thoughts as well.
It's important to remember that most state constitutions do not enumerate powers in the way the federal does either. And so you have both unenumerated powers and unenumerated rights, and much of this is directed to, understood to be directed to the legislature and not to be judicially enforceable.
Yeah, and with respect to the states, the problem is that the Constitution as a legal instrument does not take those fiduciary norms and make them legal with respect to the states. It doesn't mean they aren't fiduciaries. It doesn't mean that there aren't legal fiduciary norms. It's just whether this particular legal instrument is a source of those norms. And I think with respect to the states, the answer is no.
Jamal, do you have anything on this before we wrap up?
The answer is yes.
All right, so everybody.
Well, may I speak to the necessary and proper point? Because I think what Randy said is not a fair summary of the history here. So in that 2-year period, the reason why there were not a lot of federal laws that violate anything that would be in the Bill of Rights is because of the enumeration of powers. And so we didn't have rights, we didn't have federal laws about speech or press until the Alien and Sedition Acts in 1798. And that was Hamilton's and many people's answer to the demand for a Bill of Rights, is that the federal government was so carefully limited in what it could do that natural rights wouldn't be affected. The supporters of the Bill of Rights very effectively refuted the Hamiltonian position by pointing out the various ways in which the enumerated powers of Congress could be used in such a way that would invade these rights. George Mason, for example, talks about the collection of taxes in the port cities, and maybe the tax collectors would break into merchants' warehouses without a warrant. So we need some kind of protection against that. Freedom of the press was a favored example. And if they won that argument, the supporters of the Bill of Rights won the argument for a Bill of Rights, and the reason they won is that the word proper did not, nobody thought it did, protect these rights. We needed a Bill of Rights precisely because there was no such protection.
All right, so I'm going to make a soft promise on behalf of my panelists that they might stick around for a little bit at the end here.